7. Fundamental rights. The fundamental rights are enshrined in Part 3 of the Constitution from Articles 12 to 35. In this regard, the framers of the Constitution derived inspiration from the Constitution of USA, i.e., Bill of Rights. Part 111 of the Constitution is rightly described as the Magna Carta of India. It contains a very long and comprehensive list of justiciable fundamental rights. In fact, the fundamental rights in our Constitution are more elaborate than those found in the Constitution of any other country in the world, including the USA. The fundamental rights are guaranteed by the Constitution to all persons without any discrimination. They uphold the equality of all individuals, the dignity of the individual, the larger public interest and unity of the nation. The fundamental rights are meant for promoting the ideal of political democracy. They prevent the establishment of an authoritarian and despotic rule in the country, and protect the liberties and freedoms of the people against the invasion by the state. They operate as limitations on the tyranny of the executive and arbitrary laws of the legislature. In short, they aim at establishing a government of laws and not of men. The fundamental rights are named so because they are guaranteed and protected by the Constitution, which is the fundamental of the land. They are fundamental also in the sense that they are most essential for the all-round development, material, intellectual, moral and spiritual, of the individuals. Originally, the Constitution provided for 7 fundamental rights viz. 1. Right to equality, Articles 14 to 18. 2. Right to freedom, Articles 19 to 22. 3. Right against exploitation, Articles 23 to 24. 4. Right to freedom of religion, Articles 25 to 28. 5. Cultural and educational rights, Articles 29 to 30. 6. Right to property, Article 31. 7. Right to constitutional remedies, Article 32. However, the right to property was deleted from the list of fundamental rights by the 44th Amendment Act, 1978. It is made a legal right under Article 300A in Part 12 of the Constitution. So at present, there are only 6 fundamental rights. Features of fundamental rights. The fundamental rights guaranteed by the Constitution are characterized by the following. 1. Some of them are available only to the citizens while others are available to all persons whether citizens, foreigners or legal persons like corporations or companies. 2. They are not absolute but qualified. The state can impose reasonable restrictions on them. However, whether such restrictions are reasonable or not is to be decided by the courts. Thus, they strike a balance between the rights of 7.2. Indian polity. The individual and those of the society as a whole, between individual liberty and social control. 3. All of them are available against the arbitrary action of the state. However, some of them are also available against the action of private individuals. 4. Some of them are negative in character, that is, place limitations on the author of the state, while others are positivity of in nature, conferring certain privileges on the persons. 5. They are justiciable, allowing persons to know of the courts for their enforcement, move if and when they are violated. 6. They are defended and guaranteed by the Supreme Court. Hence, the aggrieved person can directly go to the Supreme Court, not necessarily by way of appeal, against the judgment of the high courts. 7. They are not sacrosanct or permanent. The Parliament can curtail or repeal them but only by a Constitutional Amendment Act and not by an ordinary act. Moreover, this can be done without affecting the basic structure of the Constitution. The amenability of fundamental rights is explained in detail in Chapter 11. 8. They can be suspended during the operation of a national emergency except the rights guaranteed by Articles 20 and 21. Further, the 6 rights guaranteed by Article 19 can be suspended only when emergency is declared on the grounds of war or external aggression, i.e., external emergency, and not on the ground of armed rebellion, i.e., internal emergency. The suspension of fundamental rights during a national emergency is explained in detail in Chapter 16. Their scope of operation is limited by Article 31A, saving of laws providing for acquisition of estates, etc. Article 318, validation of certain acts and regulations included in the 9th schedule, and Article 10, easing of laws giving effect in certain directive principles. 10. Their application to the members of armed forces, paramilitary forces, police forces, intelligence agencies and analogous services can be restricted or abrogated by the Parliament, Article 33. 11. Their application can be restricted while martial law is in force in any area. Martial law means military rule, imposed under abnormal circumstances to restore order, Article 34. It is different from the imposition of national emergency. 12. Most of them are directly enforceable, self-executory, while a few of them can be enforced on the basis of a law made for giving effect to them. Such a law can be made only by the Parliament and not by state legislatures so that uniformity throughout the country is maintained, Article 35. Definition of state. The term state has been used in different provisions concerning the fundamental rights. Hence, Article 12 has defined the term for the purposes of Part IIL. According to it, the state includes the following. A. Government and Parliament of India, that is, executive and legislative organs of the Union Gov. B. Government overment and legislature of states, that is, executive and legislative organs of state government. C. All local authorities, that is, municipalities, panchayats, district boards, improvement trusts, etc. D. All other authorities, that is, statutory or non-statutory authorities like LIC, ONGO, SAIL, etc. Thus, state has been defined in a wider sense so as to include all its agencies. It is the actions of these agencies that can be challenged in the courts as violating the fundamental rights. According to the Supreme Court, even a private body or an agency working as an instrument of the state falls within the meaning of the state under Article 12. Fundamental Rights. 7.3. B. Temporary laws like ordinances. Laws inconsistent with fundamental rights. Article 13 declares that all laws that are inconsistent with or in derogation of any of the fundamental rights shall be void. In other words, it expressly provides for the doctrine of judicial review. This power has been conferred on the Supreme Court, Article 32, and the High Courts, Article 226, that can declare a law unconstitutional and invalid on the ground of contravention of any of the fundamental rights. The term law in Article 13 has been given a wide connotation so as to include the following. A. Permanent laws enacted by the Parliament or the state legislatures. Table 7.1 Fundamental Rights at a glance. Category 1. Right to equality, Articles 14 to 18. 2. Right to freedom, Articles 19 to 22. 3. Right against exploitation, Articles 23 to 24. 25 to 281. Right to freedom of religion, Article 5. Cultural and educational rights, Articles 29 to 30. 6. Right to constitutional remedies. Issued by the President or the state governors, C. Statutory instruments in the nature of delegated legislation, executive legislation, like order, bylaw, rule, regulation or notification, and D. Non-legislative sources of law, that is, custom or usage having the force of law. Thus, not only a legislation but any of the above can be challenged in the courts as violating a fundamental right and hence, can be declared as void. Further, Article 13 declares that a constitutional amendment is not a law and hence cannot be challenged. However, the Supreme Court held in the Kesavananda Bharti case, 1973, that a constitutional amendment can consist of a. Equality before law and equal protection of laws, Article 14, b. Prohibition of discrimination on grounds of religion, race, caste, sex or place of birth, Article 15. C. Equality of opportunity in matters of public employment, Article 16. D. Abolition of untouchability and prohibition of its practice, Article 17. A. Abolition of titles except military and academic, Article 18. A. Protection of 6 rights regarding freedom of I, speech and expression. I. Assembly, in, association, v. Movement, v. Residence, and v. Profession, Article 19. B. Protection in respect of conviction for offences, Article 20. C. Protection of life and personal liberty, Article 21. D. Right to elementary education, Article 21A. A. Protection against arrest and detention in certain cases, Article 22. A. Prohibition of traffic in human beings and forced labor, Article 23. B. Prohibition of employment of children in factories, etc. Article 24. A. Freedom of conscience and free profession, practice and propagation of religion, Article 25. B. Freedom to manage religious affairs, Article 26. C. Freedom from payment of taxes for promotion of any religion, Article 27. D. Freedom from attending religious instruction or worship in certain educational institutions, Article 28. A. Protection of language, script and culture of minorities, Article 291. B. Right of Monetas to establish and administer educational institution, Article 301. Right to move the Supreme Court for the enforcement of light including the arts of Habit Corpus Mana Proluban di Art, and Ex Querento, Arole 22. For Indian polity. Table 7.2 Fundamental Rights, FR of foreigners. FR available only to citizens and not to foreigners. 1. Prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth, Article 15. 2. Equality of opportunity in matters of public employment. Article 16. 3. Protection of 6 rights regarding freedom of 1. Speech and expression. Assembly, association, IV, movement. V. Residence and V. Profession, Article 19. 4. Protection of language, script and culture of minorities. Article 29. 5. Right of minorities to establish and administer educational institutions, Article 30. FR available to both citizens and foreigners, except enemy aliens. 1. Equality before law and equal protection of laws. Article 14. 2. Protection in respect of conviction for offences. Article 23. Protection of life and personal liberty. Article 21. 4. Right to elementary education. Article 21A. 5. Protection against arrest and detention in certain cases, Article 22. 6. Prohibition of traffic in human beings and forced labor, Article 23. 7. Prohibition of employment of children in factories etc. Article 24. 8. Freedom of conscience and free profession, practice and propagation of religion, Article 25. 9. Freedom to manage religious affairs, Article 26. 10. Freedom from payment of taxes for promotion of any religion, Article 27. 11. Freedom from attending religious instruction or worship in canteen educational institutions, Article 28. Be challenged on the ground that it violates a fundamental right that forms a part of the basic structure of the Constitution and hence, can be declared as valid. Right to equality. 1. Equality before law and equal protection of laws. Article 14 says that the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. This provision confers rights on all persons whether citizens or foreigners. Moreover, the word person includes legal persons, WICs, statutory corporations, Comper MES, registered societies or any other type of legal person. The concept of equality before law is of British origin while the concept of equal protection of laws has been taken from the American Constitution. The first concept connotes a. The absence of any special privileges in favor of any person, b. The equal subjection of all persons to the ordinary law of the land administered by ordinary law courts, and c. No person, whether rich or poor, high or low, official or non-official, is above the law. The second concept, on the other hand, connotes a. The equality of treatment under equal circumstances, both in the privileges conferred and liabilities imposed by the laws, b. The similar application of the same laws to all persons who are similarly situated, and c. The like should be treated alike without any discrimination. Thus, the former is a. Fundamental rights. 7.5. Negative concept while the latter is a positive concept. However, both of them aim at establishing equality of legal status, opportunity and justice. The Supreme Court held that where equals and unequals are treated differently, Article 14 does not apply. While Article 14 forbids class legislation, it permits reasonable classification of persons, objects and transactions by the law. But the classification should not be arbitrary, artificial or evasive. Rather, it should be based on an intelligible differential and substantial distinction. Rule of law. The concept of equality before law is an element of the concept of rule of law, propounded by A.V. Dicey, the British jurist. His concept has the following three elements or aspects. 1. Absence of arbitrary power, that is, no man can be punished except for a breach of law. Equality before the law, that is, equal subjection of all citizens, rich or poor, high or low, official or non-official, to the ordinary law of the land administered by the ordinary law courts. The primacy of the rights of the individual, that is, the Constitution is the result of the rights of the individual as defined and enforced by the courts of law rather than the Constitution being the source of the individual rights. The first and the second elements are applicable to the system, to the Indian system, not the third one. In the Indian system, the Constitution is the source of the individual rights. The Supreme Court held that the rule of law as embodied in Article 14 is a basic feature of the Constitution. Hence, it cannot be destroyed even by an amendment. Exceptions to equality. The rule of equality before law is not absolute and there are constitutional and other exceptions to it. These are mentioned below. 1. The President of India and the Governor of States enjoy the following immunities, Article 361. 1. The President or the Governor is not answerable to any court for the exercise and performance of the powers and duties of his office. No criminal proceedings shall be instituted or continued against the President or the Governor in any court during his term of office. No process for the arrest or imprisonment of the President or the Governor shall be issued from court during his term of office. No civil proceedings against the President or the Governor shall be instituted during his term of office in any court and done by him in his person respect of any act personal capacity, whether before or after he entered upon his office, until the expiration of 2 months next after notice has been delivered to him. 2. No person shall be liable to civil or criminal proceedings in any court in respect of the publication in a newspaper, or by radio or television, of a substantially true report of any proceedings of either House of Parliament or either House of the Legislature of a state, Article number 361A. 3. No member of Parliament shall be liable to any proceedings in any court in respect of anything said or any vote given by him in Parliament or any committee thereof, Article 105. 4. No member of things in any shall be liable to any 5. Of a state court in respect of anything said or any vote given by him in the legislature or any committee thereof, Article 194. Article 31C is an exception to Article 14. It provides that the laws made by the state for implementing the directive principles contained in Clause B or Clause C of Article 39 cannot be challenged on the ground that they are violative of Article 14. The Supreme Court held that, where Article 1 to 6 comes in, Article 14 goes out. '76. Indian polity. 6. The foreign sovereigns, rulers, ambassadors and diplomats enjoy immunity from criminal and civil proceedings. 7. The UNO and its agencies enjoy diplomatic immunity. 2. Prohibition of discrimination on certain grounds. Article 15 provides that the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex or place of birth. The two crucial words in this provision are discrimination and only. The word discrimination means to make an adverse distinction with regard to, or to distinguish unfavorably from others. The use of the word only connotes that discrimination on other grounds is not prohibited. The second provision of Article 15 says that no citizen shall be subjected to any disability, liability, restriction or condition on grounds only of religion, race, caste, sex, or place of birth with regard to a. Access to shops, public restaurants, hotels and places of public entertainment, or b. the use of wells, tanks, bathing ghats, road and places of public resort maintained wholly or partly by state funds or dedicated to the use of general public. This provision prohibits discrimination both by the state and private individuals, while the former provision prohibits discrimination only by the state. There are 4 exceptions to this general rule of non-discrimination. A. The state is permitted to make any special provision for women and children. For example, reservation of seats for women in local bodies or provision of free education for children. B. The state is permitted to make any special provision for the advancement of any socially and educationally backward classes of citizens or for the scheduled castes and scheduled tribes. For example, A. Reservation of seats or fee concessions in public educational institutions. C. The state is empowered to make any special provision for the advancement of any socially and educationally backward classes of citizens or for the scheduled castes or the scheduled tribes regarding their admission to educational institutions including private educational institutions, whether aided or unaided by the state, except the minority educational institutions. D. The state is empowered to make any special provision for the advancement of any economically weaker sections of citizens. Further, the state is allowed to make a provision for the reservation of up to 10% of seats for such sections in admission to educational institutions including private educational institutions, whether aided or unaided by the state, except the minority educational institutions. This reservation of up to 10% would be in addition to the existing reservations. For this purpose, the economically weaker sections would notified by the state from time to time on the basis of family income and other indicators of economic disadvantage. Reservation for OBCs in educational institutions. The above exception, C, was added by the 93 Amendment Act of 2005. In order to give effect to this provision, the Center enacted the Central Educational Institutions Reservation in Admission Act, 2006, providing a quota of 27% for candidates belonging to the other backward in all Central Higher Edu classes, OBCS, educational institutions including the Indian Institutes of Technology, ITS, and the Indian Institutes of Management, IIMs. In April 2008, the Supreme Court upheld the validity of both the Amendment Act and the OBC Quota Act, but the court directed the central government to exclude the creamy layer, advanced sections, among the OBCS while implementing the law. Fundamental Rights 7.7. The children of the following different categories of people belong to creamy layer among OBCS and thus will not get the quota benefit. 1. Persons holding constitutional posts like President, Vice President, judges of SC and HCS, chairmen and members of UPSC and SPSCS, CEC, CAG and so on. 2. Group A, Class 1 and Group B, Class 2 officers of the All India, Central and State Services, and employees holding equivalent posts in PSUs, banks, insurance organizations, universities, etc., and also in private employment. 3. Persons who are in the rank of colonel and above in the Army and equivalent posts in the Navy, the Air Force and the paramilitary forces. 4. Professionals like doctors, lawyers, engineers, artists, authors, consultants and so on. 3. Persons engaged in trade, business and industry. 6. People holding agricultural land above a certain limit and vacant land or buildings in urban areas. 7. Persons having gross annual income of more than 38 lakh or possessing wealth above the exemption limit. In 1993, when the creamy layer ceiling was introduced, it was 1 lakh. It was subsequently revised to 2.5 lakh in 2004, 24.5 lakh in 2008, 76 lakh in 2013 and 78 lakh in 2017. Reservation for EWSs in educational institutions. The above exception, D, was added by the 103 Amendment Act of 2019. In order to give effect to this provision, the Central government issued an order, in 2019, providing 10% reservation to the economically weaker sections, EWSS, in admission to educational institutions. The benefit of this reservation can be availed by the persons belonging to EWSs who are not covered under any of the existing schemes of reservations for caste and OBCs. The eligibility criteria laid down in this report is as follows. 1. Persons whose family has gross annual income below 38 lakh are to be identified as EWSs for the benefit of reservatien. The income would include income from all sources, i.e., salary, agriculture, business, profession, etc. And it would be income for the financial year prior to the year of application. 2. Persons whose family owns or possesses any one of the following assets are to be excluded from being identified as EWSs, irrespective of the family income. A. 5 acres of agricultural land and above. B. Residential flat of 1000 square feet and above. C. Residential plot of 100 square yards and above in notified municipalities. D. Residential plot of 200 square yards and above in areas other than the notified municipalities. 3. The property held by a family in different locations or different places, cities would be clubbed while applying the land or property holding test to determine EWS status. 4. Family for this purpose would include the person who seeks benefit of reservation, her parents and siblings below the age of 18 years as also her spouse and children below the age of 18 years. 3. Equality of opportunity in public employment. Article 16 provides for equality of opportunity for all citizens in matters of employment or appointment to any office under the state. No citizen can be discriminated against or be ineligible for any employment or office under the state on grounds of only religion, race, caste, sex, descent, place of birth or residence. There are 4 exceptions to this general rule of equality of opportunity in public employment. Seven point 8. Indian polity. A. Parliament can prescribe residence as a condition for certain employment or appointment in a state or union territory or local authority or other authority. As the Public Employment Requirement as to Residence Act of 1957 expired in 1974, there is no such provision for any state except Andhra Pradesh and Telangana. B. The state can provide for reservation of appointments or posts in favor of any backward class that is not adequately represented in the state services. C. A law can provide that the incumbent of an office related to religious or denominational institution or a member of its governing body should belong to the particular religion or denomination. D. The state is permitted to make a provision for the reservation of up to 10% of appointments or posts in favor of any economically weaker sections of citizens. This reservation of up to 10% would be in addition to the existing reservation. For this purpose, the economically weaker sections would be notified by the state from time to time on the basis of family income and other indicators of economic disadvantage. Mandal Commission and Aftermath. In 1979, the Morarji Desai government appointed the Second Backward Classes Commission under the chairmanship of B.P. Mandal, a member of parliament, in terms of Article 140 of the Constitution to investigate the conditions of the socially and educationally backward classes and suggest measures for it toward its repart in 1980 and identified as many as 3,743 castes as socially and educationally backward classes. They constitute nearly 52% component of the population, excluding the scheduled cases, SCS, and the scheduled tribes. The Commission recommended for reservation of 27% government jobs for the other backward classes, OBCA, so that the total reservation for all, SC, ST and OBCA, amounts BOM. It was altered on years in 1990 that the VP Singh government declared reservation of 27% government jobs for the OBCs. Again in 1991, the Narasimha Rao government introduced two changes. A. Preference to the poorer sections among the OBCs in the 27% quota, i.e., adoption of the economic criteria in granting reservation, and B. Reservation of another 10% of jobs for poorer, economically backward, sections of higher castes who are not covered by any existing schemes of reservation. In the famous Mandal case, 1992, the an extent of Article 16(4), with scope for reservation of jobs in favor of backward classes, has been examined thoroughly by the Supreme Court. Though the court has rejected the additional reservation of 10% for poorer sections of higher castes, it upheld the constitutional validity of 27% reservation for the OBCs with certain conditions, viz. The advanced sections among the OBCs, the creamy layer, should be excluded from the list of beneficiaries of reservation. B. No reservation in promotions. Reservation should be confined to initial appointments only. Any existing reservatien in promotions can continue for 5 years only, i.e., up to 1997. C. The total reserved quota should not exceed 50% except in some extraordinary situations. This rule should be applied every year. D. The carry-forward rule in case of until backlog vacancies is valid. But it should not violate 50% rule. That advancement. The Commission submit a permanent statutory body should be established to examine complaints of over-inclusion and under-inclusion in the list of OBCs. With regard to the above rulings of the Supreme Court, the government has taken the following actions. 4. Pam Nandan Committee was appointed to identify the creamy layer among the OBCs. It submitted its report in 1993, which was accepted. Fundamental Rights. 79. B. National Commission for Backward Classes was established in 1993 by an Act of Parliament. Its mandate was to examine the complaints of under-inclusion, over-inclusion or non-inclusion of any class of citizens in the list of backward classes for the purpose of job reservation. Later, the 102 Amendment Act of 2018 conferred a constitutional status on the Commission and also enlarged its functions. For this purpose, the amendment inserted a new Article 338B in the Constitution. C. Order to nullify the ruling with regard to reservation in promotions, the 77th Amendment Act was enacted in 1995. It added a new provision, Article 16, that empowers the state to provide for reservation in promotions of any services under the state in favor of the SCs and STs that are not adequately represented in the state services. Again, the 15th Amendment Act of 2001 provides for consequential seniority in the case of promotion by virtue of rule of reservation for the government servants belonging to the SCS and ST with retrospective effect from June 1995. D. The ruling with regard to backlog vacancies was nullified by the 81st Amendment Act of 2000. It added another new provision in Article 16 that empowers the state to consider the unfilled reserved vacancies of a year as a separate class of vacancies to be filled up in any succeeding year or years. Such class of vacancies are not to be combined with the vacancies of the year in which they are being filled up to determine the ceiling of 50% reservation on total number of vacancies of that year. In brief, it ends the 50% ceiling on reservation in backlog vacancies. A. The The 76th Amendment Act of 1994 has placed the Tamil Nadu Reservations Act of 1994 in the 9th schedule to protect it from judicial review as it provided for 9% of reservation, far exceeding the 50% ceiling. Reservation for EWSs in public employment. The above exception, D, was added by the 103rd Amendment Act of 2019. In order to give effect to this provision, the central government issued an order, in 2019, providing 10% reservation to the economically weaker sections, EWSs, in civil posts and services in the Government of India. The benefit of this reservation can be availed by the persons belonging to EWSs who are not covered under any of the existing schemes of reservation for SCs, SPS and OBCs. The eligibility criteria laid down in this regard has already been explained under Article 15. Further, the scientific and technical posts which satisfy all the following conditions can be exempted from the purview of this reservation. I. The posts should be in grades above the lower grade in Group A of the service concerned. E. They should be classified as scientific or technical in terms of Cabinet Secretarian Order, 1961, according to which scientific and technical posts for which qualifications in the natural sciences or exact sciences, applied sciences or in technology are prescribed and the income hence of which have to use that knowledge in the discharge of their duties. E. The posts should be for conducting research or for organizing, guiding and directing research. 4. Abolition of untouchability. Article 17 abolishes untouchability and forbids its practice in any form. The enforcement of any disability arising out of untouchability shall be an offense punishable in accordance with law. In 1976, the Untouchability Offences Act, 1955 has been comprehensively amended and renamed as the Protection of Civil Rights Act, 1955 to enlarge the scope and make penal rovers more stringent. The Act defines civil right as any right accruing to a person by reason of the abolition of unknowability by Article 17 of the Constitution. Seven 10. Indian polity. The term untouchability has not been defined either in the Constitution or in the Act. However, the Mysore High Court held that the subject matter of Article 17 is not untouchability in its literal or grammatical sense but the practice as it had developed historically in the country. It refers to the social disabilities imposed on certain classes of persons by reason of their birth in certain castes. Hence, it does not cover social boycott of a few individuals or their exclusion from religious services, etc. The Supreme Court held that the right under Article 17 is available against private individuals and it is the constitutional obligation of the state to take necessary action to ensure that this right is not violated. 5. Abolition of titles. Article 18 abolishes titles and makes 4 provisions in that regard. A. It prohibits the state from conferring any title, except a military or academic distinction, on anybody, whether a citizen or a foreigner. B. It prohibits a citizen of India from accepting any title from any foreign state. C. A foreigner holding any office of profit or trust under the state cannot accept any title from any foreign state without the consent of the President. D. No citizen or foreigner holding any office of profit or trust under the state is to accept any present, emolument or office from or under any foreign state without the consent of the President. From the above, it is clear that the hereditary titles of nobility like Maharaja, Raj Bahadur, Rai Bahadur, Rai Sahib, Dewan Bahadur, etc., which were conferred by colonial states are banned by Article 18 as these are against the principle of equal status of all. In 1996, the Supreme Court upheld the constitutional validity of the national awards Bharat Ratna, Padma Vibhushan, Padma Bhushan and Padma Shri. It ruled that these awards do not amount to titles within the meaning of Article 18 that prohibits only hereditary titles of nobility. Therefore, they are not violative of Article 18 as the theory of equality does not mandate that merit should not be recognized. However, it also ruled that they should not be used as suffixes or prefixes to the names of awardees. Otherwise, they should forfeit the awards. These national awards were instituted in 1954. The Janata Party government headed by Morarji Desai discontinued them in 1977. But they were again revived in 1980 by the Indira Gandhi government. Right to freedom. 1. Protection of 6 rights. Article 19 guarantees to all citizens the 6 rights. These are I. Right to freedom of speech and expression. E. Right to assemble peaceably and without. E. Right to form associations or unions or cooperative societies. 10. IV. Right to move freely throughout the territory of India. V. Right to reside and settle in any part of the territory of India. V. Right to practice any profession or to carry on any occupation, trade or business. Originally, Article 19 contained 7 rights. But, the right to acquire, hold and dispose of property was deleted by the 44th Amendment Act of 1978. These 6 rights are protected against only state action and not private individuals. Moreover, these rights are available only to the citizens and to shareholders of a company but not to foreigners or legal persons like companies or corporations, etc. The state can impose reasonable restrictions on the enjoyment of these 6 rights only on the grounds mentioned in the Article 19 itself and not on any other grounds. (1778). Fundamental Rights. 7.11. Freedom of speech and expression. It implies that every citizen has the right to express his views, opinions, belief and convictions freely by word of mouth, writing, printing, picturing or in any other manner. The Supreme Court held that the freedom of speech and expression includes the following. A. Right to propagate one's views as well as views of others. B. Freedom of the press. C. Freedom of commercial advertisements. D. Right against tapping of telephonic conversation. A. Right to telecast, that is, government has no monopoly on electronic media. F. Right against bundh call by a political party or organization. G. Right to know about government activities. H. Freedom of silence. 1. Right against imposition of pre-censorship on a newspaper. 1. Right to demonstration or picketing but not right to strike. The state can impose reasonable restrictions on the exercise of the freedom of speech and expression on the grounds of sovereignty and integrity of India, security of the state, friendly relations with foreign states, public order, decency or morality, contempt of court, defamation, and incitement to an offense. Freedom of assembly. Every citizen has the right to assemble peaceably and without arms. It includes the right to hold public meetings, demonstrations and take out processions. This freedom can be exercised only of public land and the assembly must be peaceful and unarmed. This provision does not protect violent, disorderly, riotous assemblies, or one that causes breach of public peace or one that involves arms. This right does not include the right to strike. The state can impose reasonable restrictions. The exercise of right of assembly on 2 rounds. namely, sovereignty and integrity of India and public order, including the maintenance of traffic in the area concerned. Under Section 144 of Criminal Procedure Code, 1973, a magistrate ch. restrain in assembly, meeting or procession if there is a risk of obstruction, annoyance or danger to human life, health or safety, or a disturbance of the public tranquility, or a riot or any affray. Under Section 141 of the Indian Penal Code, as assembly of 5 or more persons becomes unlawful if the object is a. to resist the execution of any law or legal process, b. to forcibly occupy the property of some person, c. to commit any mischief or criminal trespass, d. to force some person to do an illegal act, and a. to threaten the government or its officials on exercising lawful powers. Freedom of association. All citizens have the right to form associations or unions or cooperative societies. It includes the right to form political parties, companies, partnership firms, societies, clubs, organizations, trade unions, or any body of persons. It not only includes the right to start an association or union but also to continue with the association or union as such. Further, it covers the negative right of not to form or join an association or union. Reasonable restrictions can be imposed on the exercise of this right by the state on the grounds of sovereignty and integrity of India, public order and morality. Subject to these restrictions, the citizens have complete liberty to form associations or unions for pursuing lawful objectives and purposes. However, the right to obtain recognition of the association is not a fundamental right. The Supreme Court held that the trade unions have no guaranteed right to effective bargaining or right to strike or right to declare a lockout. The right to strike can be controlled by an appropriate industrial law. Freedom of movement. This freedom entitles every citizen to move freely throughout the territory of the country. He can move freely from one state to another or from a place to another within a state. This right underlines the idea that India is one unit so far as the citizens are concerned, and thus, the purpose is to promote national feeling and parochialism. Seven point 12. Indian polity. The grounds of imposing reasonable restrictions on this freedom are two, namely, the interests of general public and the protection of interests of any scheduled tribe. The entry of outsiders in tribal areas is restricted to protect the distinctive culture, language, customs and manners of scheduled tribes and to their traditional vocation and safeguard their properties against exploitation. The Supreme Court held that the freedom of movement of prostitutes can be restricted on the ground of public health and in the interest of public morals. The Bombay High Court validated the restrictions on the movement of persons affected by AIDS. The freedom of movement has two dimensions, viz., internal right to move inside the country, and external right to move out of the country and right to come back to the country. Article 19 protects only the first dimension. The second dimension is dealt by Article 21, right to life and personal liberty. Freedom of residence. Every citizen has the right to reside and settle in any part of the territory of the country. This right has two parts. A. The right to reside in any part of the country, which means to stay at any place temporarily, and B. The right to settle in any part of the country, which means to set up a home or domicile at any place permanently. This right is intended to remove internal barriers within the country or between any of its parts. This promotes nationalism and avoids narrow-mindedness. The state can impose reasonable restrictions on the exercise of this right. Two grounds, namely, the interest of general public and the protection of interests of any scheduled tribes. The right of outsiders to reside and settle in tribal amas is restricted to protect the distinct type culture, language, customs and manners of scheduled tribes and to safeguard their traditional vocation and properties against exploitation. To many parts of the country, the tribals have been permitted to regulate their property rights in accordance with their customary rules and laws thereof. The Supreme Court held that certain areas can be banned for certain kinds of persons like prostitutes and habitual offenders. From the above, it is clear that the right to residence and the right to movement are overlapping to some extent. Both are complementary to each other. Freedom of profession, etc. All citizens are given the right to practice any profession or to carry on any occupation, trade or business. This right is very wide as it covers all the means of earning one's livelihood. The state can impose reasonable restrictions on the exercise of this right in the interest of the general public. Further, the state is empowered to a. Prescribe professional or technical qualifications necessary for practicing any profession or carrying on any occupation, trade or business, and b. Carry on by itself any trade, business, industry or service whether to the exclusion, complete or partial, of citizens or otherwise. Thus, no objection can be made when the state carries on a trade, business, industry or service either as a monopoly, complete or partial, to the exclusion of citizens, all or some only, or in competition with any citizen. The state is not required to justify its monopoly. This right does not include the right to carry on profession or business or trade or occupation that is immoral, trafficking in women or children, or dangerous, harmful drugs or explosives, etc. The state can absolutely prohibit these or regulate them through licensing. 2. Protection in respect of conviction for offenses. Article 20 grants protection against arbitrary and excessive punishment to an accused person, whether citizen or foreigner or legal person like a company or a